So good morning. Today's daf is daf Mem Hey. We are near the very bottom of Mem Daled Amabet. We are in the middle of a discussion. Again, we're still in the parak of Cheskas Batim that deals with the concept of chazaka and the ability to not, to establish the fact that you are the owner of property, notwithstanding the fact that you don't have any documentation. But we've spent the last 2 days attempting to describe the situation covered by the following brisa. The brisa says that if someone sells a house or a field, the seller may not testify on behalf of the buyer because of the guarantee. And we've understood that because of the guarantee that the seller was giving the buyer, but it doesn't have to be that way. Indeed, we saw that it may not be. And if someone sells a cow or a talus, then the seller may testify on behalf of the buyer because there's no guarantee provided by the seller. Again, is unclear to whom it's talking about. So the Gemara initially offered an explanation by Rav Sheshis, but yesterday we rejected it as it didn't fit well with the language. There was nothing halakhically wrong with it, but it just didn't fit with the language. Abaye in particular noted the fact that it seemed to be that everything seemed to be based on whether or not the original owner would get the property back. And that was the question as to whether or not they could testify. The other thing is that it wasn't the the original owner who was doing the seller, it was a thief who was doing the seller. Nonetheless, the bottom line is that that we rejected that approach. We then offered an explanation by Rav and Bar Shmuel. Rav and Bar Shmuel said in the name of Shmuel that the brisa means that if one sells a field without a guarantee, the seller may not testify on behalf of the buyer regarding the field because doing so keeps the field available to the seller's creditors, and it's those creditors who have the guarantee. So it's because of the guarantee that was provided by the seller to other creditors with respect to that real property. But when one sells movable property, the seller can testify because the property does not come with it the ability for creditors of the seller to take it away. Now, we noted yesterday one exception to that. It is possible to tie a movable property to be claimable by one's creditors if one ties that movable property to real estate. And so we ended up saying that we have to know that this seller never owned any land. And that way we'll know that he never had a chance to tie even movable property to be claimable by creditors. Mm-hmm. So Robin had mentioned during the course of his conversation, of his description, that the field was sold without a guarantee. So the Gemara now delves into that and attempts to understand the circumstances of that statement. So as we pick up with the fourth line from the bottom of Mem Daled Amabet, with the word gufa, second to last word on the line. So let's take a look and see what we have to say. So gufa, again, this is the statement by Rav and Bar Shmuel. Amar Rav and Bar Shmuel, Mishmei de Shmuel, Hamocher sadel lechaveiro shelo b'achrayis ein meid lo aleha. That when you sell the real property to somebody and you don't include a guarantee on it, well, then you're not allowed to testify on it because now you have a benefit by keeping it in its current location. Now, again, remember that if in fact potentially you sold it with a guarantee, and it's only a guarantee against other creditors, then maybe you would be able to testify because you don't get any benefit because anything that's taken away from this buyer with respect to the property, you're going to have to pay. You're going to have to pay him back. So you never reduce the amount that you're owed. But here, because you sold it without a guarantee, when somebody else comes and takes it, you're going to be able to reduce the amount that you owe. So hechidami. But what's the case? Let's figure this out. Meaning, what's the status of this debtor slash seller of the real estate? So we turn now to Memhei Amud Aleph. So Islay Ara Achrisi, if he's got other property, Ale Dide Hadar, well then the creditor needs to go to that other property because that's the requirement. You can only go to the Mushubad property if in fact the guy's got nothing else. But if he's got other property, you got to take the property from him. You can't just go to some customer that he had, and so as a result, why should he care whether or not there's any ability, whether this property gets retained in the buyer's hands? He has other property. He's wealthy enough. The bottom line is it doesn't matter. So, and delays lay ara achrisi, and if there isn't other land, so my nafka, what difference does it make to him? Why? The bottom line is he's judgment proof. So why should it matter to him? Now, we actually answered this question when we learned yesterday, and the Rashbam reminds us, and the Gemara will tell us what that answer, but let's take a look and see Rashbam explain the question for a second line in the narrow lines of Rashbam. Why should the seller care whether the land remains in the hands of the buyer? Ha'afilu imapik la me'arer lo matzi gabi bal chovo minei democher midi dehalesle. Because the point is that what difference does it make to the seller if in fact the complainant, remember we called the complainant Yehuda. Yehuda was trying to take it away from Ruvain, who bought the field from Shimon. And now Yehuda, even if Yehuda is successful, why should Shimon care? Because at the end of the day, he's judgment proof. There's nothing that's going to be collected from him. So why should he care? So,
but he has a benefit.
Yeah, what's the benefit?
That he doesn't have to pay the chov that he owes.
But he doesn't have to pay the chov because he doesn't have any money. So why? So where's the benefit? Again, the answer is pretty obvious.
Why do you say he doesn't have money?
Well, that's the presumption, right? He has no other land. He has no other property that he can from which he can pay the debt. The assumption is that he doesn't have any other assets, right? Because if he has other assets, why should he care about keeping it with the buyer? Because he's got other assets and he's going to have to pay out of those other assets. So either way, it seems like he shouldn't care, and therefore he should be able to testify.
No, weren't we saying yesterday that he would have
100%?
He would be glad. He would be glad that he doesn't, that this land would be taken. He benefits because he doesn't have to pay now. He doesn't.
100%. We're going to get back to there in about 2 minutes. But before we get back to there, I want to just note a couple of things. So first, let's take a look at the top two Tosos. Right? If in fact he's got other lands, so then the guy's going to have to go to him, right? So now the Gemara answers, the Tosos notes, Havamatzi l'shnuye. We could have answered here, Kagon sha'asa apoteki, that maybe he made this real property an apoteki. Now, Tosos is assuming, remember we saw this yesterday, that when you sell a slave that's an apoteki, it goes with the slave. So naturally, he's assuming that if you sell real estate that's an apoteki, well then the creditors can continue to claim from the apoteki. The azlo hadar achrisi. In that, if he made it into an apoteki, and now even if he sold it, the creditors still get to go to that apoteki first. The islay, that even if he has other property, they don't go after that. The im tipol biyad hama'arer, and therefore, if that land, the apoteki land, were to end up in the hands of the complainant, Yifare lo acheret. He will have to give up other land. Umishum haki eino meyed aleha denogea be'edusu. And so he would be an Ogea Be'eda. So the point is that Tosfos is acknowledging that the Gemara had a number of different potential answers here. Okay, but in any event, my nafkamino. So what difference does it make? Meaning, why should he care if he doesn't? If he's judgment proof, why should he care? And so tema to nafkamina sheyapatru im yitasher. Shouldn't he care if he becomes wealthy? And one could effectively ask that same question in connection with what if he had other properties? Maybe all of a sudden he'll lose those properties before the creditor comes to collect. The Shema Bishvil Cain Ain Lepos Lola Edis. So Tosfos offers a suggestion that actually the risk of your change in status is not considered a risk that will make you an invalid witness. Because at the moment you have no need for it. So as a result, those are the two Tosfos there. Thought that those were interesting Tosfos. So now the Gemara asks again. The question is, why are we saying, how come the seller can't testify no matter what? Because either he has other property, and so he doesn't need this property to pay the guy back, or he has no other property, so even if he doesn't pay the guy back, who cares? He's judgment proof. So it's not like he's going to have to pay otherwise. So la'olam delays le arachrisi. Really, he has no other land. Da'amar, but what is the concern? Lo nika de lahavi lova Russia lo yishalim. There's a pasuk. This is a pasuk in Tehillim, Perek Lamed Zayin, pasuk Kaf Aleph, that says, that there's this concept of a wicked, a wicked borrower that doesn't pay, and people don't want to be that. So even though he isn't going to lose any money, he will lose a reputation, and reputation does matter. And so as a result, that's why we're going to say that actually we're talking about a situation where he has no other property, and he still can't testify because he wants to make sure that the property remains so that he doesn't get called a Russia. Well, 1 second. What about the poor purchaser? When the purchaser loses that property, won't the debtor / seller end up being a Russia vis-a-vis that person, that seller, that purchaser? No, he won't be, because the Amr lahachizvini lach shalobach rayas. That's why I sold it to you without a guarantee. And so as a result, we've gone back. We've now explained what Rashbam explained yesterday, that in fact, we're dealing with a situation where the person doesn't want to be a Russia. And so as a result, he'll effectively want to try and maintain the property with his seller. And that's why we're not going to allow him to testify. Okay, so that is the end of this discussion. And so again, in the end, we say that this brisa is talking about a seller who sells property, and the issue is the guarantee that property provides against other creditors coming to collect. And so if he doesn't sell the property with a guarantee on this most recent sale, well, then all of a sudden now he's not going to be able to testify for the purchaser because he wants to keep the purchase, the property with the purchaser. On the other hand, when it comes to the cow or the talus, which doesn't get sold with which doesn't provide a guarantee against other creditors, it's because he doesn't have any real estate to connect it to. So as a result, there's no guarantee. And as a result, maintaining the property with the seller won't matter. And therefore, we're going to say that he is allowed to testify in that circumstance.
So what is the point that we said he has no money? Ultimately, he still has a chov to the previous,
correct,
to the person, to the
money.
Malva, right? Still has a chov. So he doesn't have money today, but he may have money tomorrow. And in fact, and not only that, the chov now is that can be assumed through the acquisition of the property by the Malva, right?
Correct. And so in the end, that's exactly right. We say that because he's not because he, even though he doesn't have money, we're going to say that he still can't testify because he cares whether or not he's viewed as a Russia who doesn't pay back, and he wants to be somebody who pays back. And so as a result, he's not going to be allowed to testify about real property that he sells.
But the property is ultimately taken from the buyer by the Malva, right?
Well, it depends. I mean, he's assuming that nobody else comes and complains, etc. Then yeah, it could very well be. Again, remember that the story is
So
that
that's a
now,
benefit to him.
correct, and that's why he's not allowed to testify.
So I'm still, I don't understand the Havamina to think that if he doesn't have money, then he is free and he could testify.
Well, if he doesn't have money, then what is the benefit that he gets? The answer, if you're going to tell me, well, because doesn't get called to Russia, well, then you've just told me the answer. So, meaning the Gemara's thinking initially is that in order to have a benefit, it has to be a monetary benefit. And in the beginning, there is no monetary benefit because he doesn't have any money anyway. So as a result, if he doesn't have any money, so then where's the monetary benefit? And the answer is that no, monetary benefit is not what we're talking about. We're talking about a benefit of reputation. Okay,
It
we
still
can talk about it
seems,
more
yeah, I hear what you're
afterwards.
saying, but it still seems that there could be one could think there's a monetary benefit because ultimately the property that he supposedly sold or thought he sold or did sell or was then taken from the person to whom he sold it because he got money from that property, right?
Right, but he got money from that property, but he doesn't have that money anymore. Otherwise, he would pay back. Hold on just a second. We got an issue here with the okay. No worries, that's okay. The point is that he doesn't have the money, so he's not saving anything because he wasn't going to have to pay otherwise. That's precisely the Havamina, that he doesn't that because he's not going to have to spend money. All right, we need to
Okay,
move
okay,
on.
all right, all right.
So I'm happy to discuss this further.
Okay, I'm digesting it here. Okay.
Okay. So the next, so now the Gemara, in our Mishnah, we noted that a craftsman does not get a chazaka. So Rabbah is going to qualify this rule, meaning that if I bring to you, you're my tailor, Stan. If I bring to you my a suit, then you can't say that the suit was actually sold to you because you're a craftsman. Everybody knows that people bring to you things to repair. So when we say that, Machriz Rava, V'item Rav Papa, either Rava or Rav Papa said about it. And by the way, the other aspect that we're going to be touching on here, I'm sorry. I'm sorry. I apologize. We're on number 2. I skipped ahead on the screen. We mentioned yesterday that according to Rav Papa, who allows a buyer ordinarily to get reimbursed, even when the purchase was made without a guarantee. So if I sell you property, Stan, without a guarantee, but it turns out I never owned it, Rav Papa says that you can still come back to me, right? And it makes sense. There's a right now, of course, if I sell it to you without a guarantee and some creditor of mine comes, then you lose. And Rav Papa would agree that you don't. That's what it means when I sell it without a guarantee. Of course, we saw that Rav Zvid disagrees with Rav Papa, and Rav Zvid says no. When you sell without a guarantee, it's a guarantee against even not owning the property. And in fact, it seems like that's how we paskin. But nonetheless, Rav Papa allows you, Stan, to come back to me if you said you didn't, if it turns out that I didn't own it. Now, there's an exception to that. Even Rav Papa would agree that if, in fact, you know that the animal that I sold to you was the child of one of the animals that I had, you could recognize it's so obvious that it's descended from my animal. So in that situation, even if it turns out that some third party is able to prove that they are the real owners and that I don't own it, you know that actually was false testimony. Unfortunately, sometimes false testimony will win, because you don't have your own witnesses. And so in that situation, Rav Papa would agree that you don't have the ability to come back to me. And we're going to see that same statement right now. And that's why we're bringing this case. So Makras Rava ve'itema Rav Papa, desalkin la'ela ude nachatin latasa. That the Rava announced for everybody who's going going up, meaning to Eretz Yisrael, and everybody who's going down, meaning to Babel. Hi Bar Yisrael, if a Jew, who sells his donkey to another Jew, and a non-Jew comes and takes away that donkey from the Jew. Dinahu demivtze mine. The law is that the selling Jew needs to see if he can appease the non-Jew and effectively effectuate the sale. Meaning, I sold to you my donkey, and now Chris comes in and he grabs the donkey away from you. So, what is the facts of this case? Is it just that Chris is coming in as like a thief? No, we're not dealing with that situation. So let's take a look.
Is that after the donkey transferred?
Sorry?
Is that after the donkey
transferred? Yes, after the donkey transfer. Thank you for asking that question. Below Amran Elisheinu Makir Ba Shehi Bat Chamoro. But as we saw a moment ago, as we saw in connection with the other situation, we're assuming that Stan does not recognize that my animal truly is mine. So on some level, the non-Jew is claiming ownership of this animal, claiming some aspect of legitimate ownership. Aval makir ba shehi bat chamoro lo. If in fact Stan recognizes that the animal that I sold him, the donkey that I sold him, was definitely mine. He knows that it was mine. It was not. So now that Chris has come and taken it away, I don't have that same requirement to appease Chris. Okay? Villo Amran, and also I don't have that same obligation to appease Chris. Ela delo honestly lidire luchpa. That if it's also when Chris doesn't come and take both the animal and the saddle, meaning if he takes everything, he doesn't just take the animal, he takes everything that's on the animal. It's clearer in that situation that he's coming to steal. But aval honestly lidide ula uchpa lo. If he just takes the donkey and he leaves behind the saddle, which he could have very well, meaning he's a muscular guy, this Chris. If he wanted to, he could have taken, the whole thing, and he didn't. Well, now all of a sudden we're going to understand that he's trying. He thinks he has a legitimate legal claim, and so that's why I have to go appease. So Amar Amar afilu leka kolhani low. That even if none of these disqualifying conditions are present, so then I also don't have to. My timer made yada distam obed kochavim anasu. Because in general, we understand that a non-Jew is a thief. And so as a result, Shneamar Asher PM Diber Shav Viminim Yamin Shaker, meaning that their mouths speak vanity, their right hand is falsehood. The point is that this is again a pasuk in Tehillim Kuf Mem Dalid pasuk Chet. The bottom line is that we say that because of this, basically we're going to assume that this is a theft, and therefore I don't have to try to appease him. Okay, now Tosfos asks an interesting question here. Dinahu de mitzapile, third Tosfos down. Tema l'Rashba. The Rashba wants to know. Delemale isi raya de bedin tarfa. V'asholem lach. Show if I say Stan is my purchaser. Stan purchased the donkey from me. Maybe I should be able to, God bless you. Maybe I should be able to tell Stan, listen, Stan, Chris took it away from you, but I'm saying Chris is a thief. So if you want me to do something about it, you should bring evidence that Chris is not a thief and Chris had a legitimate claim. Meaning if instead of if it wasn't Chris, it was Moshe who took away this donkey because he had a legitimate claim, or he just took it forcibly, I would be able to say to Stan, listen, show me that Moshe took it away legitimately, and of course I'll pay you back for it. So Haki Kol Shekain. So here I should definitely be able to tell Kol Shekain Lagabi Akum. I should definitely be able to tell Stan that he needs to bring proof with witnesses. So Yesh Lomar Demairi Kagon Shabedine Akum Dan Imo. That we're going to say that actually we're dealing with a situation where Chris took Stan to a Christian court, and the Christian court ruled for Chris, and so as a result, Obadinehem Kavya Da'akum and Hilkach Chayav Lefetzuso. So the point is that I'm obligated to appease and to figure out a way to get Stan the donkey because Chris took it away from Stan in a legitimate matter in a court proceeding. And so therefore it might not have been a Jewish court proceeding, but he took it away in a court proceeding. So the bottom line is we have these two different viewpoints. And again, it seems like we're going to follow a Maimar that in fact we don't worry about this at all. But the bottom line is it's an interesting perspective that suggests that maybe if a non-Jew were to take something that we would have to worry about, that the seller would need to try and make things right by the purchaser, even if the purchaser had no specific guarantees.
Okay. So then he would have to pay, the seller would have to pay the buyer his loss, right?
Correct. That's according to Rava or Rav Papa. In the end, again, we paskin like a Maimar. So the answer is that if it's stolen by a non-Jew, we are taken by a non-Jew, even if it's taken under the color of law, we're not going to require the Jew to pay it back. Okay.
So that's considered honest then.
Correct. And it's considered an honest, and it's considered as if we presume that the non-Jew is really stealing. And so as a result, but of course, if the Jewish customer can prove that in fact the non-Jew was the legitimate owner, and that I never actually owned the property,
right? Okay.
So then there might be then he would have a claim.
But suppose the buyer takes the thief, which is the non-Jew, to court.
Well, to which court? Jewish court?
Well, that's a question. I mean,
the point is that the non-Jewish court already found for the non-Jew. So and that's why he was allowed to take it away, according to Tosfos. So it doesn't seem likely that he's going to take him to the non-Jewish court. And the Jewish court, why would Chris go to the Jewish court?
Why would he even show up?
Exactly. So that's the story. So, but again, in the end, the question is, if it was sold without a guarantee, so then it would seem like, a Stan would be up a creek without a paddle. All right. Uman ein lo chazaka. So again, we said that a craftsman doesn't get a chazaka, and what we meant by that is that if Stan is a tailor and I bring him my suits, well then he can't say that he owns the suits. So we're going to qualify that. So Amaraba lo shanu ela shemaser lo be'edim. When we say that Stan cannot say that the suits that I have that are in his possession I actually sold to him, it's because I gave those suits to Stan with witnesses. Aval masalo shelo be'edim. If I gave it to him without witnesses, mitoch sheyachal lo marlo lo hayu dvarim ma'olam, because Stan could say, nothing ever happened to it. Meaning you never gave me anything. Ki amar leinami lekuchucha he biyadi mehemen. So because he has a valid claim, a valid statement that would allow him to win the case, by saying that he never saw those suits ever, because I have no evidence that I ever gave them to him. So then he will believe him when he says that he purchased them. Amrle Abaye, Abaye asks a question. Ihachi afilu be'edim nami. Well, in second, if in fact I gave you the suits, gave Stan the suits with witnesses, well, there's a situation where he should be believed as well to say that he bought them. Mitoch sheyachol lomar lo hechazartiv lach. I could have said that I gave them back to you. Ki amar leila kuchli biyadi mehemen. He should be believed because he said that he purchased it from you. So Amarle Abaye, misvarat. Do you really think, as we turn to Memhei Amabet, Hamafked Eitzel Chaveru Be'edim, Eino Tzarech Lahachzer Lo Be'edim? Lo! Salka Daitach Ella, Hamafked Eitzel Chaveru Be'edim, Tzarech Lahachzer Lo Be'edim. So if I give you something in front of witnesses, then you, when you give it back to me, you need to give it to me in front of witnesses. So therefore, if I in fact give my suits to Stan with witnesses, he doesn't have the ability to say that he gave them back to me, and therefore believe me that when I say I purchased them, because he would have had to have witnesses that he gave them back to me. So that is so now
it seems that the owner of the suits that he gave to the craftsman could have maybe a different or stronger claim. You could say, listen, you're a craftsman. I'm giving you a product. You're going to claim it's yours. Not only am I never going to give it, because he's known in the community as a craftsman. Not only am I never going to give them to you, I'm going to make a call in the community that this is a crooked craftsman and you're not going to have any business. So it's not in his interest to say that these were mine, that the craftsman interest to say they were really mine, because he's going to lose all business. No one's going to come to him.
Well, again, it depends on who's more trustworthy, the craftsman or the person who's making that claim, right? I mean, if if somebody who has been a craftsman for many years, and especially what is the craftsman supposed to do if in fact he does buy the suits from the person, meaning Stan realized that the suits that I gave him were particularly nice and they all fit him so beautifully. And he's like, listen, David, I know I could, I know you brought them into repair, but I want to buy these suits off you. I'm willing to offer you a great price. And I'm like, fabulous. That's great. Cause, I have enough other suits. So what are we supposed to do? The bottom line is that, I guess what we can do is make sure that Stan can make sure that he's got witnesses. That's what he could do. But the bottom line is that again, we're dealing with a situation where somebody's clearly lying. And again, you have to be careful. You don't want to always presume that one of the sides is lying. You have to look at it as if either side could be lying. But in any event, the bottom line is you're absolutely right, and that's what we're saying. We're trying to limit the situation of when we say in our Mishnah that a craftsman cannot get a chazakah. What's the story? So again, Meisvei Abaye asks another question. We have a brisa. Ra avdo biyad uman. If you see your slave in the hands of the craftsman. Now, what is the slave doing in the hands of the craftsman? Take a look at the Rashbam, 3, 6, 7 lines down, last word on the line. Ra avdo biyad uman, shemilamdo umanut, who's teaching him the profession. So that's why he happens to be there. Or betalizo biyad koves, back into the Gemara. We're now 1, 2, 3, 4 lines down, the last word on the line. Vitalizu biyad koves, or we're dealing with a talus in the hands of a launderer. Omer lo matiu etzlecha. And now that I saw that my item with the guy, I say to him, what is this thing doing in your possession? Meaning it belongs to me. Amar lo atamakartoli atanasatali bimatani. You either sold it to me or you gave it to me as a present, is what he answers. So lo amar klum. So the craftsman has not said anything, meaning he doesn't have a valid chazakah, even though it's in his possession. Bifanai amarta lo lemochro velitno li b'matana dvarav kayamin. However, if he says that you told this other person in my presence to sell it or give it to me, well, then what he said is true. Now, of course, Maishna Resha, Maishna Seif. So before we understand exactly what Abaye's challenge is, we need to understand what's the difference between the first case and the second case. Meaning, why are we believing the guy in the second case? So Amar Rabba explains the reason that we're beginning to believing this guy in the second case is Seifa biyotzu mitachas yadei acher. No, in the second case, it's no longer the craftsman who's speaking, it's a third party. So it's a different situation. So the first case is when I go to the craftsman, I go to Stan and I say, Stan, what are you doing with my talus? What are you doing with my slave? And he says that you sold it to me or you gave it to me as a gift. And so as a result, I said that, so that is totally meaningless and I get to take my talus or my slave back. But if instead of it being Stan, it was Ken who was holding my slave or my talus, and when I try to get it back from Ken, Ken says, "Listen, it was in front of me that you said you told that I heard you tell the launderer, the craftsman that he was supposed to give it to me, or that he was supposed to sell it to me." So then Dvarav Kayamin. Then Ken has a valid claim, and we'll see why in a moment. So let's take a look. And here's what the third party is saying. This is what Ken's saying. You're the one who, in my presence, you told this other person, presumably the craftsman or the launderer, to sell or give that item to me. So, and we should believe Ken because migo de boy amarle minaxvante, because Ken has the ability to say that he bought it directly from me, and he would have been believed because he's not a craftsman and he's not a launderer. So ki amarle nami b'fanei amarta lo lemokro dvarav kayam umehemen. So similarly, when he now says that it was in front of him that I told Stan to sell it to him or to give it to him, we're going to believe him. But the bottom line is, so now we understand the brisa. But what's the question that Abaye is asking? Well, katani mias reisha ra. The point is that why did we need to say that I saw that Stan had my talus or my slave in his possession? Hechidami, what are we talking about? Because if you tell me that there are witnesses, lama lira, why do I need to say that I saw it? After all, even without seeing it, I have witnesses that say that I gave it to Stan. Nasi Edim Minishkol. I can bring my witnesses, and now I'll be able to take back the item. Meaning, even if I didn't see it, I can force the court to go into Stan's property, find the item, and give it to me. So it must be that there are no witnesses. But 1 second, Rabba said that if there are no witnesses, the craftsman can have a legitimate claim by saying that he bought it. And yet, nonetheless, we're seeing that the original owner has the ability to get back his property. So doesn't that contradict Rabbah? So lolam deika edim v'hu. The point is that you need to have witnesses and it needs to be seen. So in second, Abaye says, "V'ha'at hu de amrat hamavkid etzel chaveru be'edim tzarich lepora be'edim." 1 second, though, Rabbah, you were the one who 20 minutes ago told us that the only way that that if somebody receives something with witnesses, the only way they're allowed to give it back is also with witnesses. So why do I need to have seen the item in your possession? So Amrlo Hadri B. So Abaye says back, "Oh, I went back on that. I changed my mind." So so where do we end up? So
change his mind about what?
He changed his mind about his statement that if you receive something with witnesses, you must give it back in front of witnesses.
Wow.
So where do we end up with Rabbah's statement? Here's where we are at the moment.
If he didn't see it, then how does he know that the evidence is by the craftsman? Or how would he even know this? He has to see it, right?
No. The point is that he gave the guy the craft. He gave his slave. He told his slave to go over to the craftsman in order to train. He literally gave his talus to the launderer. So the point is, and he did so in
Okay, that
front of
was a
witnesses,
question
according to
from the
Rob.
beginning. If it says the right that begins, he says who ra'ah, and I was wondering why is that Evid by the craftsman? Did he get permission to go there?
Well, again, Rashbam told us that he was there in order to learn a craft.
Correct, but who
And
told? But what did he get permission to
of
learn the
course he
craft?
got, I mean, that's why he was there. I sent him there. Meaning if I, again, Stan is my craftsman in our example. I'm the owner of the particular item, and I sent it to him. And of course, again, according to Rava, this brisa is also understood to be involving a two witnesses. So I had witnesses that I brought my slave over and said, Stan, would you do me the favor of training my slave? And
Well,
so, and Stan said, yes, of course, I'd be happy to. And now,
well, it seems
3 weeks
strange
later,
then. In
and
that
now let me finish. Now,
yeah.
3 weeks later, Stan is saying, no, you didn't bring this slave for me to train. I bought the slave from you, and I'm training him because he's going to be my slave, and he's going to be my assistant.
Yeah.
And I'm like, what? Oh my gosh, that's terrible. So the fact is that because Stan is a craftsman, and because I saw my slave in Stan's possession, so he has no longer an ability to say lo hayu dvarim me'olam, that there was I never gave it to him, or because I also gave it to him in front of witnesses, he can't say, listen, I gave it back to you, and I don't know what you're talking about, because but he can't say that he gave it back to me, because we see and I saw, and and the Rashbam says that I saw in front of witnesses, and I have witnesses that I saw that my slave is still there, or I saw that my talus is still there. And so as a result, that's the situation. And so we've ended up with a couple of things. So let me just try and summarize. Rabbah says that in order for in order for Stan the craftsman to not be able to claim chazaka, you have to have given the item to Stan in front of two witnesses. Not only that, but you also need witnesses that Stan still has the item. So only in that situation is a situation where Stan doesn't have the right to say that I purchased it. But if either I never gave Stan the item in front of witnesses, so as a result, there is no one who can testify that I gave it to Stan as a craftsman, well, then Stan can claim that he purchased it from me, because he could say that he doesn't know what I'm talking about at all, and I would have no basis to get anything from him. And even if I gave it to him in front of witnesses, if I don't have any evidence that he's still holding the item, then also Stan will be believed to say that I purchased it, because he could say that he gave back the item. Right. And so that is where we end up at the moment.
Why does it even? I don't understand the last point. If the craftsman is no longer holding the item, where's the question?
No. Remember, I can't prove that he's holding the item. The answer is that he admits that he's holding the item. But my only proof that he's holding the item is his statement that, yes, I'm holding your item, but I bought it from you. Right? And so as a result, when that's the only proof that I have that it's still in his possession, well, now all of a sudden he has a good migo, because he could say that I gave it back to you. He could have said that I gave it back to you. And because he could have said that I gave it back to you, because in the end, Rabbah agrees, and I believe that the halacha is this way, that if you gives me something to watch with two witnesses, I have no obligation to give it back to you with two witnesses. May not be the smartest thing, maybe good advice for me to give it back to in front of two witnesses, but I have no obligation to. And so now, when you see it still in my possession, when we see the slave still in Stan's possession, so now I gave it to him in front of two witnesses. We see it still there. Now we're not going to believe him to say that he purchased it. Now, because he's a craftsman.
it's a lot of onus on the original owner to always have two witnesses whenever you drop off something to be repaired or fixed or made.
Correct. That's correct. That's correct. Again, obviously, the beauty of actually having somebody that you trust is that that then you don't have to do that because you trust the person. But we're dealing with a world, a place like New York City where you don't deal with people frequently enough, and so as a result, there isn't that sense of communal trust. So
it just seems a little strange that the bright that begins with Ra'ah.
Well,
He
that's
sees
exactly the
the
question.
yeah, he
That's
sees
Abaye's
the
question. Abaye's question is why did you the brisa begin with Ra'ah? Doesn't that show that it must be that there were no witnesses? And the answer is no, there were witnesses and Ra'ah, because you need both. That's exactly the point that Rabbah responds. You need both to have given it with two witnesses, and you need some evidence that you know that it's still with the craftsman, because otherwise, without that evidence that your object that you gave to the craftsman is still with the craftsman has the ability to respond, I gave it back to you, and now and so I owe you nothing. And
still with.
because he could say I gave it back to you and I owe you nothing, and he would win in that case, now also we're going to allow him to say, you're right, I still have it, but I bought it from you.
Yeah. Well, what would be the alternative to say that you're saying you're emphasizing it's still with the craftsman, but where would it be if it's not with the craftsman? Where would it be?
It would be with you. Maybe he
Well,
gave it back to you and you were the one who lost it. Remember, in all these cases, we don't know who the liar is. Maybe he gave it back
right,
to
but
you.
then
You
he didn't
picked it
see
up
it.
from
Then
him.
if he gave it, if it's not with the craftsman and with somewhere else, then he can't really say, "Listen, I saw it with you." The guy, he can't say, he can't."
Yes, that's exactly right. That's the point. We're dealing. There are three different possibilities here. One possibility is you never gave it with witnesses. If you never gave it with witnesses, because Stan could say there was never anything here, he's going to be believed to say that he purchased it. Another situation is you gave it to him with two witnesses, but you don't see that it's still there. In that situation, Stan would be believed to say you gave it back to him, that he gave it back to you. And so as a result, he can also say that he purchased it from you. And then there's the third situation where not only did you give it with two witnesses, but you also have witnesses that you saw it with Stan still holding it. In that situation, because Stan is a craftsman, we're not going to allow him to say that he bought it from you. Unlike if you were to give it to me, Ken, even if you gave me the items with two witnesses, and even if you have witnesses that say that it's still in my possession, because I'm not a craftsman and possession is 9/10 of the law, I win if I say, yeah, of course I have it because Ken sold it to me. Okay, so those are the four different possible situations that we can be involved in. Again, we can have no witnesses whatsoever, Stan wins, even though he's a craftsman. We can have two witnesses and no evidence that it's still with him, Stan wins, because he could say he gave it back. We could have two witnesses and evidence that it's still in his possession, then Stan loses if he's a craftsman. But you know what? If you had given it to me, who's not a craftsman, I would win in that situation. So we have four situations, and in three of the situations, the person who's holding the item is going to win, because in general, possession is 9/10 of the law. It's only because we understand that a craftsman is going to take an item that doesn't belong to him, and often will be holding items that don't belong to him, that we are going to put an additional restriction that says we're not always going to believe him. And again, this is only the status of where we are at the moment. Rabbah is now going to try.
How do you in the second situation that you mentioned, you said that that the owner gave it to the craftsman and it's no longer with the craftsman. How does the craftsman then win? Because he doesn't have it anymore.
No. We don't. It's not that it's no longer with the craftsman. It's that we have no evidence that it's that it's still with the craftsman. Remember, the craftsman is now going to say that, of course, it's with me. I purchased it. So he admits that it's with him, but that's the only evidence that we have that it's with him in the second case.
But
Okay.
I thought you said that when you delineated the cases, that
No,
was
no. So
that we don't, that it's no longer with him.
No, he has the ability to say that it's no longer with him, and therefore we're going to believe him when he says that he purchased it.
Oh, he said, but I thought you said it's no longer with him.
No. If I did, that was an accident.
He could sell it.
Yes, and who can sell it? Stan can sell it. Yeah, the craftsman can sell it, exactly, because now and certainly if the craftsman sells it and gives it to somebody else, we're going to, when it's in that other person's possession, so then it's going to be even harder to get it away from him, because that person is not a craftsman. And he'll be believed that especially if there's no evidence of the purchase from the craftsman. That's the case of that's the latter case in that brisa, right? If instead of Stan holding it, again, I have it, and I claim that you, Ken, gave it to Stan and told Stan to give it to me, and as a gift, I'm going to be believed. And the reason that I'm going to be believed is because I could have just said I bought it from you. So as long as I have a legitimate claim, I can't just say that you gave it to Stan and you didn't tell him to give it to me and he gave it to me and he sold it to me. That wouldn't be enough because Stan is a craftsman. I need to have a legitimate claim. But all right, but in any event, this is where we are at the moment. Don't think that this is where we end up. I don't want anybody to think we are not done in our efforts supporting and challenging Rabbah's limitation on our Mishnah to where the original owner.
A craftsman could take everything and just sell it right away. You have no witnesses to say it's in his possession, and he wins every time.
No, that's exactly the point. He will not win because the only way that his customer will be able to retain it is if he says that the person who gave it to Stan told Stan and to sell it to him, to sell it to the person who's holding it, and that person who's holding it saw that happen. Because if all I say is Stan sold it to me, because Stan is a craftsman, that it will not be a legitimate claim, right? Because Stan doesn't have the right to sell things. I would need.
No, you give it to Stan to repair.
I give it to Stan. All right, so I'm not the.
Stan turns around and sells it to Ken.
Correct. So what is Ken claiming? If Ken is
that's not the case. But then you can't go to Stan and say he has it because he doesn't have it anymore.
Correct.
And therefore Stan wins.
So obviously somebody will need to tell me that it's in Ken's possession, right? Because you're absolutely right. I'm not going to win in my litigation against Stan any longer because Stan doesn't have it. You're absolutely right. I need to somehow find Ken, and now I litigate with Ken, and Ken says, well, I bought it from Stan. That will not be enough. Meaning if Ken is honest and says that he bought it from Stan, he does not have a legitimate claim to the ownership of the item.
What if I sold him stolen goods?
Right, same thing.
Yeah.
Same thing. Now, if it's stolen goods, then we add the question of whether I was miyayish it. Did I give up hope of ever recovering it? Right. If I gave up hope of ever recovering it, so then Ken will win, and my only claim against you is monetary.
Gotcha.
Is monetary, and then I bring witnesses that you in fact stole.
It's not a slam dunk.
No, not a slam dunk at all. Again,
my point was
highlighting
if he sells it, you're not going to see it again, and then you don't have any claims. My point was if he sells it, you're not going to see it again, and there goes your claim.
Correct. Somebody needs to tell me that Ken has it. If nobody ever tells me that Ken has it, you're absolutely right. My claim is gone.
Craftsman could steal a lot of things easily.
Yes, that's why you need to trust the craftsman. 100%. 100%. Yeah. No, the bottom line is that if I don't know who's holding my item, I'm up a creek. All right. So,
but you do know you gave it to the craftsman.
Yes, exactly. And so maybe I can help. Maybe I can find witnesses that show that that saw Stan sell it to you, Ken. If I have witnesses that saw Stan sell you my item, so then then I will have a
But
legitimate
even if you
claim.
don't, even if you have witnesses that you gave it to the craftsman, that then and it disappears, you can still hold the craftsman liable.
No, because the problem is that Stan can just say that he gave it back to me.
Well, then where is it then?
You're right. He's going to say that I lost it, right? Remember, because it could be that he's honest and that he really did give it back to me and I really did lose it. And so he shouldn't lose this litigation, right? The important thing to remember is that we have to be able in our minds to flip who it is that's lying and who's telling the truth, because it doesn't always have to be that the customer, even though we say the customer is always right, it doesn't have to be that the customer isn't the one who's lying. So, all right. So again, we're not done in our effort supporting and challenging Rabba's limitation of our Mishnah to where the original owner gave the item to the craftsman in front of witnesses. So stay tuned for the continuation of this conversation tomorrow. Shabbat Shalom. Have a great Shabbos. Looking forward to continuing our learning together. Be well, everybody.
Good Shabbos, Rabbi.